So, Mr. Siddiqui, please, if you keep responding to each question, we'll be forever. No, excuse me. This is no laughing matter.
My Lord,
no, from morning to night on the first day we worked, every second of this court is time of the people who have invested heavily in this institution. 3 full days have worked. Now we are on the 4th day. We can endlessly hear one case in the year, and that's our performance. And all the other cases will get left behind, and all they will keep mounting up. So please, there are 15 of us, and all of us have questions, and undoubtedly valid questions. Please complete your chain of thought, and if you keep responding, I don't know what your contention is, I will never understand it.
If I may just complete this.
Please keep submitting your submissions.
I'm very grateful to your Lordship. If your Lordships may see Order 1, it contains various definitions, my Lord, and then your Lordship may see subsection 2. If I may read. Unless the context, now law is not defined in the Supreme Court rules, but this provision is there. Unless the context otherwise requires, the General Clauses Act 1897 shall apply to the interpretation of these rules as it applies to the interpretation of a federal act. Your Lordships are aware that the term law is a defined term in the General Clauses Act. And this is the General Clauses Act 1897 I'm talking about. If your Lordship looks at Section 3, subsection, sorry sir.
Order 1, 2, 2 है ना जरा clear कर.
जी.
Order 1 का rule 2 का 2.
जी, rule 2.
जी.
Rule 2 का 2.
जी, rule 2 का 2. I'm sorry sir. So the definition of what law means in Order 11 would come from the General Clauses Act. And Section 3, subsection 37B has a definition of law. It says Pakistani law, but the case law consistently says where the term law means Pakistani law, that is what Pakistani law is. And it says Pakistani law shall mean any act, ordinance, regulation, rule, order, bylaw.
Please tell us where you're reading from.
Sir, Section 3, subsection.
Sections तो नहीं है.
Sir, General Clauses Act 1897.
अच्छा, we are still at the rules, जी.
Sir, rule तो मैंने आपको बता दिया. Order 1, sub rule 2. अगर आप General Clauses Act देख लें आप, Section 3, subsection 37B.
37. Pakistani law.
So there is, as the Supreme Court which sat while making these rules was clear in their minds.
It says Pakistan law.
Yes, and the case law says that where the word law comes in statutes, and I've given the citations, I won't repeat them, that Pakistani law's definition is to be used. I've cited that. So, my lord, there is no doubt about the fact that when the word...
This is the book that I have, subsection. There's a note here saying that this was substituted in 1981.
Ji. So, 37B.
Yes, it was substituted in 1981, what you are reading. So, when the full court sat to frame the rules in Supreme Court Rules 1980, what was 37B then?
But it would still apply.
No, but what was it?
I'm not aware of that, but
Check.
yes. So, my submission before your lordship is that even if one looks at the structure of the sentence, save as otherwise provided by law, the contemplation in the mind of even while framing the rules is that there can be an act of parliament. Now, what is the relationship between that act of parliament and the rules? That is a crucial question. But there can be no question about the fact that rules, Act of Parliament can be on practice and procedure of the Supreme Court.
No, it can't.
So that's my first point.
No, just a moment.
Ji, sir.
You
Ji,
are-
sir.
First of all, you are asking us to read a definition which does not say law but says Pakistani law in the specific context of Article 191 and the Supreme Court rules. Chalo, okay, that's your argument. But you say that law...
I don't know what you say. I still have to note it. Can you please complete your thought? So let me understand what you're saying. So then the question, I will understand the question also. Maybe I'm not so quick at understanding. Can you please complete your submissions from your own mouth? Let us hear it.
My submission is that the word...
Let me first ask up to whatever you said
Please,
now.
can you I don't know the question has to follow a submission. Please, can you conclude your submission, Mr. Siddiqui? Otherwise, we'll have to spend forever on this case.
Sir, may I...
आप जरा अपना conclude कर लें submissions.
Yeah, just... Thank you, sir. Thank you. Sir, my
I
submission...
can't follow what you're
Yes,
saying.
Sir, my submission is that the word law, as it occurs in Article 191, includes acts of Parliament. And an indication of that, a clear indication of that, is given in the rules as framed in 1980, because the language, for example, used in Order 11 talks about save as otherwise provided by law. That clearly indicates that one is talking about statutory law.
Okay, next point.
Yes,
Oh,
yes.
just before
And
you carry on,
that of course is buttressed by the definition.
Just before you carry on
Ji,
to
ji,
your
sir.
next point,
Ji.
I think, if I may ask, in the 1956 Constitution, you will recall that there was a specific article which said that words and phrases not defined in the Constitution shall have the same meaning as in the General Clauses Act.
Yes.
That was in the 1956 Constitution. Is there any equivalent in the 1973 Constitution? As far as I can
I
recall,
don't...
Mr. Faisal Siddiqui, you have
I'm
been
not aware of it.
You have been rightly stumped. Please persist
Therefore,
with your submissions.
Therefore, my question to you is that here we have to look at the word law as used in Article 191, because the rule-making power is conferred by Article 191. So any definition, anything that goes in the Supreme Court Rules 1980 has to be consistent with the language of Article 191.
I'll come to that. My short answer...
Kindly you focus on that.
Yes.
What does law mean over
Yes.
there?
My short answer to that...
I think counsel.
Sir, I'll just complete my
I
submission.
think counsel is entitled to argue any which way they want to.
Achha.
Let us hear you.
Yes.
I have to hear you decide what you say, and if we have already formed opinions, we can reflect them in our judgments. Please continue.
Not a question.
Otherwise, we
I'm sorry,
will
this is
never
not a question
conclude
of
these
forming
hearings.
An opinion. This is a question that, as a judge of the court sitting on this bench, I am entitled to
Of
ask.
course,
counsel.
ask it. Let the
So I'm
counsel
asking the
finish
coun-
his submissions.
If I'm interrupted all the time, I'm sorry to say, sir, that is not proper.
I think the
I'm
interruption
asking-
is of
I'm
learned
asking-
counsel.
I'm
Chale,
asking
learned counsel,
counsel-
aap aage badhein.
I am asking counsel a question, which is my right to ask the counsel. If he wants to answer
After
it,
he
doesn't
concludes
answer
his
it.
submissions with
If
the
he
greatest
wants
of
to or
respect.
doesn't want to, that's his issue. That's not my issue. You understood the question now?
My Lord, I'll address that question. Let me just finish this submissions on competence and then I'll address this question. My Lord, so I think there can be no doubt about what the word law means in Article 191 in the context type. But if your Lordship requires a constitutional context, then subject to law also occurs in the Constitution. And it has been interpreted by your Lordships of what that means. And that has been interpreted as meaning an act of Parliament. A recent judgment on this is a judgment authored by Justice Mansoor Ali Shah Sahab in the extension case, which is PLD 2020 Supreme Court, page 1. And your Lordships are aware, if your Lordships look at 243, sub-article 3, which contained the same language, although subject to law was not in the beginning but in the middle. The President, subject to law. And His Lordship Justice Mansoor Ali Shah in para 27 of that judgment said this means an act of parliament. So then another judgment, my lord, on this would be the Baskakar case. Now, if your lordship, as your lordships are aware,
Baskakar.
Baskakar.
Okay.
But the law has been defined in the Constitution.
No. Existing law has been defined.
Kindly see 260.
Federal law is also.
Federal law has been defined.
Ji, law has not been defined. Existing
Federal law has been
Ji,
defined.
federal law has
Siddiqui
been
sir, please continue your arguments.
When 191 says of a law, does it talk of existing law or does it include a law that subsequently may be legislated?
It cannot talk about existing law because existing law is a defined term in the Constitution under Article 260. And that is a reference to Article 268, sub-Article 7. So when existing law is used, it's a defined term in the Constitution.
So where it is defined, then the Constitution must have used the term existing law somewhere.
Yes, in
Where is that?
268.
No, वो तो
It is in
defined हुई है
260.
ना.
It is in 260.
Other than the
260, yeah.
definition, where in what articles, what other articles has this term been used?
It is being used in 268. It has been defined and used in that, as far as I'm aware. But it is a defined term. So if they wanted to use existing law law would have been used.
Mr. Siddiqui, it seems that, albeit the fight is about me as being as a master of whatever, you're not hearing what I'm saying at
Sir,
all. And you're completely ignoring.
Sir, I'm not.
I mean, you don't want to make your submissions.
Sir, but I'll,
you should just sit down and answer questions.
I'll complete my submission.
So why
Now-
aren't you making your submissions?
No, my lord, leaving aside the issue.
Mr. Faisal Siddiqui, just 1 minute.
Ji.
You've given the example of Article 243. The President shall, subject to law,
Ji.
have the power to do what? Raise and maintain military, naval and air forces of Pakistan and so on.
Ji.
Well, the difference between law over here is, and this is the point that yesterday was made with other learned counsel, that this relates to a specific entry of the Federal Legislative List, i.e. entry number 1. Law over here is relatable to entry number 1, a specific entry
I'll come
of
to
the
that,
Federal Legislative List. And this was in relation to Article 202.
No, I'm simply saying that the word term subject to law as used elsewhere has been judicially defined in a certain, whether Article 191,
There's a context. What I'm asking you is,
Yes.
there's a context to Article 243, and the context that appears to be missing in relation to Article 191, where there is no specific entry, for example, in relation to the Supreme Court. So which particular legislative list would you link the use of the word
that
law?
is where I'm coming to, my lord. When it comes to practice and procedure, I will be relying on entry 58. When it comes to the appellate jurisdiction under section 5, I'll be relying on entry 55. So I'll come to now this submission. I just wanted to clear as far as this word law is concerned. Now, let me come to my first part. As your lordships are aware, there are two parts to this law. One relates to practice and procedure, and then there is section 5 which relates to appeal. Although there is a judgment by His Lordship Justice Munib where he has said as far as legislative competence is concerned, even appeals are a part of procedural law. I'll be referring to that judgment. So, if appeals are also a part of procedural law as far as legislative competence is concerned, then they would even be covered in practice and procedure law. So let me first come to how practice and procedure is covered. My lord, if your lordship may kindly see my note, I rely on entry 58 read with article 191, my lord. Now, my lord, it is, if your lordships accept my argument, which is that subject to law also includes acts of parliament, if I can safely make that presumption, then in order not to make this word redundant, there must be some power with someone to make this law in the Constitution. Otherwise, the word will become redundant. Now, that power, my lord, cannot be based on entry 55. It has to be based on entry 58. The reason I say that is entry 55 deals with, as apart from practice and procedure, it deals with jurisdictional powers. When one is talking about practice and procedure, one is not talking about jurisdictional power. I make that distinction. Now, a question was raised as to entry 58. If I may draw your lordship's attention to entry 58. It's quite a complicated entries, both of them, my lord. If your fourth schedule, sir, entry 58. Now, a question arose as to a very important term which is used in both the entries. It is by or under the Constitution. Entry 55 uses the word by or under the Constitution. Entry 58 only uses the word under the Constitution. If I may read, matters which under the Constitution are within the legislative competence of Majlis-e-Shura or relate to the Federation. What does this term under the Constitution mean as opposed to the word used in entry 55 by or under? My lord, this is a term which is used in the Constitution also, by and under the Constitution. It's used once in Article 69. It's used under the Constitution, is also used in other parts of the Constitution. Now, I think the answer is something which Justice Ijaz had given, is that under the Constitution means the necessary implications. So that is how at least the Indian Supreme Court has understood this. What necessarily follows from a certain article. It's like something which can be prima facie implied from an article. Now, my submission as far as Article 191 is concerned, my lord, is that it is not something which is very different from the rest of the entries, as Justice Munib had observed yesterday. I think it's a substantive entry. And that is how it's been understood by the Supreme Court in the sui gas case. There's a whole para on entry 58 and 59 that these are independent and substantive entries in the Constitution which independently and substantively confer competence. Now, my submission before your lordship is very simple, which is that if law in Article 199 means Act of Parliament, and if we are not to read law as in 191 as redundant, then there has to be legislative competence which has to be found somewhere for practice and procedure. Now, that place where it is found can either be entry 55 or entry 58. It cannot be entry 55 because we are not talking about jurisdiction and powers. It has to be entry 58. And entry 58 contains the key words, which is not by the Constitution but under the Constitution, as necessarily being implied. The necessary implication of an article is that it confers judicial power. So that is why one part of subject to law.
Entry 58 with what? With which article of the
191, and I also
191, you see, as the language is, the simple reading of 191 says, it is a power conferring article, and that power is conferred on the Supreme Court. So ultimately, the rules which have to be framed under Article 191 is a power of the Supreme Court, not of the Parliament.
My lord, there are two conferring powers.
In framing the rules, the Supreme Court is supposed to follow the Constitution, and I would tell you, speaking for myself, any existing law or any law that was prevalent or was in force at that time. Entry 191 does not, Article 191 does not confer legislative power on the Parliament to frame rules for the Supreme Court.
My lord, then the words under the Constitution would have to be given another meaning, because there is express conferment, as your lordships have seen in Article 188, through an Act of Parliament. And there are necessary implications, conferments which follow from the article.
آپ کا تو انٹائر تھیسس یہ ہے نا کہ جی لا کا مطلب یہ ہے an act of the parliament, whether it is existing or it is subsequently made.
Yes.
ٹھیک ہے. وہ اس صورت میں ہوتا جب 191 میں لکھا ہوتا the rules of the Supreme Court shall be framed by the Parliament. یا what was the fun or what was the rationale of giving the power to the Supreme Court in the chapter of judicature and at the same time turn around and say, well, you can frame the rules, you may frame the rules, but once you have framed the rules, the Parliament can override those rules.
Because it is a limited power. The reason is the structure of 191 is that the primary power, the primary duty under 191 is given to the Supreme Court too, so that its internal autonomy is. But
so where the primary power or the primary duty has been discharged, then the matter ends there.
No, it doesn't end there. That is why your lordship will see I broke subject to law into two parts. There is law and there is subject.
Why do I say that?
Yes.
Because the entire structure of the Constitution ensures that the judicial branch shall be insulated from not only the executive but also by the legislative intrusion. Okay? So, conferring the power to the Supreme Court means that insulation has to be maintained. Now, once you confer the power on the Parliament to override those rules, that insulation goes. Because, as it was argued yesterday, or at least it was observed yesterday, that this is an intrusion into the autonomy of the Supreme Court, which is the main theme of the Constitution.
May I address this question when I deal with the relationship between the Act and the rules? Which will prevail in what circumstance? Because that is what you're...
یہ جو amendments ہیں, do they or do they not interfere in the internal working of the Supreme Court?
Sir, the criterion is not whether they interfere in the internal working of the Supreme Court.
That is the criteria
I'll
of
show,
independence.
No, my lord, I will say there are 4 restrictions on Parliament as far as its legislative authority is concerned under Article 191, read with entry 4. Let me first state that, then I'll explain. The first restriction is that under 191, only a law relating to practice and procedure can be made. The second restriction is that Parliament can make no law, whether it's internal working or otherwise, which violates the principle of the constitutional principle of the independence of the judiciary. Number 3, and this might answer your lordship's question, Parliament cannot legislate in a way that it colonizes the power of the Supreme Court to make rules or destroys the power of the Supreme Court to make rules. It's a supervisory power. It's a checking power. It's not a power which can destroy the Supreme Court or paralyze the Supreme Court into making rules. And I think the fourth is that entry 55 and 58 still have to be read harmoniously. Parliament cannot make rules which in any way affect the jurisdiction as well as lessen the power of the Supreme Court. So these are the 4 restrictions on Parliament's powers.
Doesn't the Act affects all those 4?
I will show to your lordship it doesn't.
You have just spelt out.
I will show to your lordship it doesn't when I come to each provision of the law. So these are the 4 restrictions. I'll elaborate on this, sir. But let me
answer the initial question.
Yes.
Does it constitute an interference in the working of the Supreme Court?
Sir, I think...
Yes or no?
Sir, I would rephrase the question. The relevant question is, does it interfere in the internal working of the Supreme Court to the extent that it affects the independence of the judiciary?
Now,
That's the question.
You used the word supervise.
Yes.
isn't supervision have an element of control?
My lord, any supervision will have the element of control, but control does not mean, regulate does not mean that you destroy the power.
How can you control without interfering?
No, any supervision will imply interference. The question is, does it colonize the other person's power? Does it destroy the other person's power? Does it violate the principle of the independence of...
Where the parliament has made a law that destroys the existing rules, what does it do? It
My
does
lord,
destroy.
It doesn't destroy the existing... Now, that is a question which I will address. Relationship, agar main sirf competence agar khatam kar loon appeal ki had tak, main appeal ki had tak kyunki I've...
ایک کوشچن میرا ذرا ایڈ کر لیں چھوٹا سا.
جی
Article 191 says subject to the constitution and the law. So what does that mean? The powers given to the Supreme Court by the constitution are absolute, or is there still a room for interference? Interference means amendment, or
I would not like to use the word interference because it gives...
it's not interference. I'm sorry for that.
I would say that your lordship...
But still, the rules are the power which has been given to the Supreme Court, is that power absolute?
No, it's not absolute.
Because the first word is subject to.
Yes. Subject means conditional. It is a restriction. It can't take over the power to take rules. It can't paralyze that. That is why I would say that the Supreme Court should be insulated from external pressure. It should not be isolated. So Article 191 creates this balance where the internal autonomy of the Supreme Court stays in the hands of the Supreme Court, but subject to certain restrictions which may be imposed, and certain conditions which may be imposed by Parliament. I'll come to, because this is a crucial question, and there is a Supreme Court judgment on this, the relationship between rules and act and what prevails. I'll come to that.
If I've understood you correctly, what you're saying is that this is not, this law-making power or law as used in 191 is not a fully enabling power, but it is a power of a supervisory nature. Is that what you're saying?
It is a restrictive power.
You use the word supervisory.
Yes, I use the word supervisory in terms of that it is a power which has its limitations. That is why
one reason why I'm asking this is because you're emphasizing on linking this with entry 58.
Yes.
Which you say should be interpreted in the usual way that the legislative entry is normally interpreted.
Yes.
That would seem to necessarily imply that whatever is the subject matter of that legislative entry, it is not as such disclosed in 58, but I imagine would then be the practice and procedure of the Supreme Court. Then surely, if you read it the way you are linking it, then that would, the law-making power would cover the whole of the field of the practice and procedure of the Supreme Court, and thereby, thereby become an enabling power and not remain a supervisory or restrictive power of the nature that you are now stating. So there is this tension between what you are saying, a possible conflict. Kindly clarify this point.
My lord, there is no conflict because the language of entry 58 clarifies. Entry 58 cannot go beyond the conferment of power with necessary implication which any article of the Constitution does. So any power in terms of legislation which entry 58 does must be in the context of the power conferred by the Constitution. So if 191...
But that power, in the end, legislative entries confer power, legislative competence over a subject matter.
Yes.
A tax on income.
Yes.
The defense forces, international relations, what have you. The entry 58 of itself discloses no subject matter as such. It simply refers, because this is the point.
That is why it is limited by that constitutional provision which confers this power.
Then how do you read it as a legislative entry? Because if you now link it to the subject matter of practice and procedure, that then should
Sir, if
surely
you
covers
don't
the
read
whole
it as a
of-
legislative entry, you will make part of the entry redundant. The part of the entry says or relate to the federation.
And that's what I'm saying. That
I mean, it makes it redundant.
no, it doesn't. That's my question to you.
Yes.
Aapki jo submission hai,
Ji,
mujhe
ji,
samajh
ji,
aa
ji,
rahi
I'm
hai.
sorry, sir.
That seems to me not to be restrictive or supervisory. That would necessarily, if you link it to a legislative entry and the manner in which legislative entries are interpreted, that would have to be given the legislative competence, the power to make the law, the enabling power, whatever you want to put it, would, it seems to me, have to be interpreted in the broadest possible manner, which would mean that it would cover the whole of the field of practice and procedure, which is why Mr. Salahuddin, for example, said that yes, the Supreme Court rules can be repealed by an act of Parliament.
No, I don't take that.
Don't go there.
No,
I understand.
I don't
That's
take
why I'm asking you.
Yes.
So there is this tension
Yes.
between linking it to a legislative entry, because that's how legislative entries are interpreted, and then in the same breath or in the next breath saying that no, it can't go to the full subject matter. It is restricted to supervisory or limited nature.
Mr.
How
Lord,
do you draw the line?
these are entries which I call ping pong entries, and I'll
Mr.
explain when
Faisal,
it come to.
Mr. Faisal,
Ji.
taking the discussion further, and that's very important, what's being discussed. My understanding is, what appears to me so far is that when we have to read 191, straight away when you look at 191, there could be a restrictive meaning given to law, but we don't have to really stop there. We could also say that there could be a law, even plain reading of 191, that there could be a law that would cover the area of practice and procedure, because that's why it's subject to that law. There is a law, whenever Supreme Court goes ahead and comes up with rules, it will look at law. There could be laws relating to court fee, there could be laws relating to many things that impinge upon, but at the same time there could be a law which takes care of the whole area of practice and procedure. But when you read it with 58, it does, as my learned colleague also mentioned, makes it very expensive. It says that it is the subject matter that we'll have to look at. And it appears that when 191 is read with 58, the entry, it appears that there is legislative competence with the Parliament to legislate on the question of practice and procedure. So hence, perhaps what Mr. Salahuddin said, that it can abolish the Supreme Court rules, appears to be then correct. You can't stop halfway. You have to either accept the whole contention saying that 58, when read with 191, gives the legislative power, and then in that case they can go ahead and do whatever they want to do regarding the rules. So that's one. But what appears to me is that if 191 is read after reading 58 and you come back to 191 after reading 58, then you look at the legislative competence only, and it appears that then law, when you look at law then after 58, it appears that it gives you that legislative competence.
Happens when you look at entry 55. My position is very different from Mr. Salahuddin's
Ping
position.
pong can go on endlessly. Where does your ping pong end?
I'll come.
I think
it's
it's just
a
one
term-
way, it doesn't go back again to the entry
One
again.
thing would do.
But one more question that I want to add here, maybe you can respond to that also. Is there a difference between the word practice and procedure? Because one would have understand that it could be a procedure of the Supreme Court. What's the importance and significance of the word practice? And I say it for a reason. I say it for a reason because there are judgments of the Lahore High Court while discussing letters patent, saying that this is an internal arrangement in the, they don't consider it as an appeal. They consider it as an internal arrangement of the court, as if it were to pass for a practice. So considering that case law, written by celebrated judges of our courts, the question is, could it then be said that considering that it's an intra-court appeal, it's not an appeal in the appeal sense. That's exactly what the judgments say. It's not an appeal, it's an internal arrangement of the court. Could it then pass under the term practice under 191 to have this intra-court appeal? As you had mentioned earlier, so that's why, is there any significance of the word practice and whether intra-court appeal passes for an internal arrangement of the court and not to be considered as a substantive separate appeal?
My Lord, this is a question which to a certain extent has been answered by an opinion of Justice Munib. And I'll straight away come to that. Those are three. There is a short order by Justice. It is Justice Mandokhel who had to raise this very important issue through a short order. And then there are two opinions, one by Justice Hassan Azhar Saab, one by Justice
You
Munir.
might consider these three judgments of the Lahore High Court
Yes,
also,
I
which
can.
are...
But let me just read those, because those are actually with reference to this particular case, if I may come to those judgments. And those deal with both issues, one of competence of appeal and intra-court appeal. Both have been dealt by the two separate opinions. If your lordship will kindly see page...
that was without my opinion. Without my opinion.
लेकिन सर आपके सवाल की वजह से डिबेट शुरू हुई. आप सवाल नहीं पूछते.
Actually, this should have been that I should have been asked, what is your opinion? Without my opinion, it was sent to me.
लेकिन सर आपके खिलाफ जवाब देके भी आपके हक में जवाब दे दिया, वो देखिएगा आप जरा पेज 9 पे.
चलो मैं उसका जवाब अभी जो खत्म हो गया तो उसमें दे देंगे.
Sir, page 9 of the paper. Now, these are three unreported orders, my lord, but I think these are such crucial orders should be. If I may first to Justice Mandokhe's very interesting question, which he's been constantly raising in these proceedings. If I may come to page 9, and I'll read from the second paragraph, para 2, fifth line. The question which needs consideration is whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect of matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution. Reference is made to the order dated 13/4/2023 passed in Constitutional Petition 9 of 20. This very petition, relevant portion whereof is reproduced above. I'll leave the portion, I'll read the last 4 lines. As the issue involved is in this petition is identical to the issue involved in constitutional petition number so and so, therefore let it be placed before the Honorable. Now, on this, a dissent was done by Justice Hassan Azhar. Very interesting opinion, my lord, page 12, if your lordship may kindly see. Now, the main thrust of this opinion is on that this question did not arise in the case. That is why the case was really decided on the merit. There's a very important paragraph on this intra-court appeal, which is at page 17, para 14. It's the same content. It is the same line of argument which Justice Mazhar had alluded to yesterday. Para 14, page 17. As far as the question of whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect to matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution is concerned. So both constitutional forums, intra-court appeal in the law reforms order. I am of the humble opinion that Article 175 of the Constitution by its clause 1 ordains that there shall be a Supreme Court of Pakistan and a High Court of each province, and recognizes that such other as may be established by law. Clause 2 of that article provides that no court shall have any jurisdiction save is or may be conferred on it by the Constitution or by or under any law. For the above question, it is sufficient to say that the Supreme Court of Pakistan and the High Courts have been established by the Constitution, that they have such jurisdiction as has been conferred upon them by the Constitution, that they have also such other jurisdiction as is or may be conferred upon them by or under any law. The expression law here has been used to distinguish it from Constitution, which is higher in authority and obviously means an ordinary or sub-constitutional law made in the exercise of the powers granted by the Constitution. Reference in this regard may be made to the judgment of this court in the case of Brother Steel Mills Limited versus Mia Ilyas Miraj, PLD 96 Supreme Court 543, wherein the provision of section 15 of the Code of Civil Procedure Amendment Ordinance 1980, which also provides a right of appeal to a bench of 2 or more judges of a high court from an interlocutory order made by a single judge, that court in the exercise of its original jurisdiction has been interpreted by a 5-member bench of this court. Even otherwise, no provision of the Constitution places such bar on the power of the legislature. Both under 199 and 184.3, there is no bar that a right of appeal through a statute cannot be provided. Now, your lordship may note two things about it, and I'll come back to this. The first is that legislative competence here has been placed on Article 175(2). That's the first thing. Number two is that it has been held that even if the order is from a constitutional forum, as Justice Mandokhail had pointed out, even then an intra-court appeal can be provided through an ordinary statute. Now, it's very interesting how Justice Munib deals with this, because he extends the notion of legislative competence and agrees with Justice Hassan Azhar Rizvi on the issue of the Law Reforms Ordinance, page 20.
As a referee judge.
Ji?
As a referee judge,
Sorry? Referee judge, sir. Page 20, sir. I may read. Para 3 measure of context de do. On hearing the matter, a different opinion arose between the learned members of the bench on a point that was, it appears, framed by Jamal Khan Mandokhail, his lordship, expressed doubt whether a right of intra-court appeal could be provided by ordinary statute, like the ordinance against a decision of a single judge of the High Court, exercising jurisdiction under Article 199. Reference was made to certain pending petition filed under Article 184.3 of this court. Now, let me come to para 4. A difference of opinion has, next page, has arisen in my view. The question of law requiring resolution is as follows. Can the appropriate legislature provide by ordinary statute for a right of appeal against a decision of a single judge of a high court exercising jurisdiction under Article 199 of the Constitution, such that Section 3 of the ordinance is a valid legislature? Now, as far as where does legislative competence come, or how is appeal in terms of legislative competence to be framed? Very interesting paragraph, para 9, page 23 of this opinion. If I may read kindly from the last line. One is a right, I move to the second page, that is relatable to a specific entry on a legislative, this is the next page, 24, or to a particular legislative
I may request you kindly read the whole.
Should I read the whole, sir?
Provide
But sir.
some background.
But of course, the ordinance was not just an amending statute. It also had Section 3, which provided as presently relevant for a right of intra-court appeal in terms as noted above. That also had to be taken into account while determining its gist and substance on the commencing date. I begin by noting entry number 46 of the concurrent list. This provided in material part the legislative competence of jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list. All courts, including the High Court. Right of appeal can, for present purposes, be divided into two categories. One is a right that is relatable to a specific entry on a legislative list or to a particular legislative competence. The other is what might be called a general right of appeal. Now, these are crucial lines. Now, it is well settled that a right of appeal is a substantive right which must be expressly conferred. However, jurisprudentially, appeals in a general sense are regarded as a part of procedural law. In my view, this categorization is relevant for purposes of legislative competence insofar as a general right of appeal is concerned. Such a general right would lie in the legislative competence relating, as the case may be, to civil or criminal procedure. This conclusion is bolstered by the fact that both entries relating to criminal and civil procedure, number 2 and number 3 respectively, included therein all matters included in, respectively, the Criminal Procedure Code and CPC. Thus, entry number 3 provided in material part as follows: Civil Procedure Code and all matters included in the Code of Civil Procedure on the commencing date. The two codes of of course, contains specific provisions by way of general rights of appeal. It may be noted that the context here is legislative competence. Therefore, what was relevant was not the type of appeal encoded in the Criminal Procedure Code and the CPC, but rather the categorization thereof in terms of their nature. Thus, a general right of appeal was included in the legislative competence conferred by these two entries of the concurrent list, my lord. So, what seems, my reading is, that as far as legislative competence is concerned, when you're looking at entries, then it is not a presumption that the competence to have a law on appeal would fall within a category which does not deal with procedure. It can deal with procedure. At least that is what it's saying.
Mr. Faisal, and I think that is echoed, you might not have looked at this, but I found 53 Lahore, 284, and it's a DB judgment, and I just read this paragraph, which is important.
I found it very interesting, but I may be misreading
Which
it.
actually talks about exactly something like this, which needs to be discussed, which is a letters patent appeal is not really an appeal in the strict sense. It may be more aptly described as an internal arrangement of the court for reviewing its own decision, given in the first instance by one member of the court. The first as well as the second decision remains a decision of the court. And if you look at Order 5 Rule 2 in the rules,
there's a chamber appeal.
There is a chamber, it doesn't say appeal, it says for reconsideration to a 3-member bench. So three judges, if you see Order 5 Rule 2. So, I mean, before going into 55, let's sort this out whether at all this could form part of having an intra-court appeal.
Rule 3, Order 5, Rule 3 says appeal. Rule 3 says an appeal shall lie from registrar in all cases to
as registrar.
From
Agla pade na?
To the judges in chambers.
That's right. And then there is from a single judge to 3 judges.
Administrative order, and that's an administrative appeal.
But it's still an
Not
appeal.
a judicial order.
It's still an appeal, and it's framed under 190.
Fair enough. I mean, it probably has a color, rightly said by my colleague, that it could be administrative in nature, but we need to understand the context. If you look at Order 5 Rule 2, it talks about the power of the court in relation to power.
In relation to the following matters may be exercised by a single judge.
Can you tell us where are you reading from?
Order 5, Rule 2, Order 5, sir, Supreme Court rules.
The power of the court.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chamber, but subject to reconsideration at the instance of any aggrieved party by a bench of not less than 3 judges, which may include the judge who dealt with the matter. Your Lordship is right.
It refers to reconsideration. We don't know where to slot it. It is probably administrative in nature also. But what I'm trying to say is that intra-court appeal under these 3 judgments that I've looked at are talking about it is an internal setting and a procedure and arrangement and not considered to be substantive in that sense, which has been echoed elsewhere also. Yes. So whether at all it becomes part of a procedure of practice and procedure rather than as a substantive right.
I think this note opens up that question. If I may just read the last paragraph and then Your Lordship. Sir, as far as Justice Hassan Azhar Rizvi's opinion, which basically dealt with the merits of the case and a paragraph on the intra-court level. There's a paragraph in Justice Munib's opinion on that, which is also very important. If Your Lordship may kindly see page 25, para 12.
Para 12.
Ji sir. Page 25. In view of the above discussion, I am in no doubt that the question to me ought to be answered in the affirmative. It is so answered accordingly. I also agree with my learned colleague Hassan Azhar Rizvi that leave to appeal should be refused and leave petition dismissed. उससे ऊपर जो है 4 लाइनें वो है in contrast. My learned colleague Sayyid Hassan Azhar Rizvi has rightly noted in an order. See para 15. Now para 15 flows from para 14, dependent on para 14. That despite lapses of more than 50 years from the promulgation of the ordinance, no such question called the legality of the ordinance has been raised by any party lawyer, any high court or this court, my lord. And para 14 dealt with 2 things. There can be an intra-court appeal from a constitutional judicial forum, and secondly, the legislative competence based on Article 175, sub-Article 2, my lord.
Okay, Mr. Counsel, the thing is that you are, of course, referring to my order.
Ji, sir.
It is an order of the court, and therefore it is for others to make of it what they will.
Yes.
It is not for me to now read and interpret it, but I am picking up on the point that you think flows from this order.
Ji.
Seems to me, with respect, that it cannot conceivably flow from this order. The reason is that the issue before the court, or before me as the referee judge, was a right of appeal conferred by statute, right? And as you have read, I have noted two kinds of appeal, and the jurisprudential aspect of it, and the language of entry 3 of the current list, and so on and so forth. However, to translate this into practice and procedure as embodied in Article 191, in my view, would, and that is certainly not what this order was about, but would be incorrect. Why? For two reasons. One, because the subject matter of practice and procedure, insofar as law is concerned, you have told us that in your view it is limited, restricted, supervisory. It is not the entire breadth of the practice and procedure of the court. So if that is so, then no law which is so restricted, which is of a supervisory law-making capacity, which is restricted, supervisory, restrictive in nature, surely can confer a right of appeal in terms of that subject matter.
I think it can.
Just one more. Secondly, and more importantly, the subject matter, practice and procedure of the court is not restricted to the legislature. It is open even to the Supreme Court.
Yes.
It is primarily for the Supreme Court. So one conclusion that would follow from what you are saying is that the Supreme Court can itself create a right of appeal in exercise of practice and procedure. Is this what you are arguing?
My lord,
In relation to Section 5 now,
My
the
lord,
context
my
here is
lord,
Section
my
5.
lord.
So tomorrow the full court amends the Supreme Court rules and creates a right of appeal. Can
my
it do
lord,
that?
my lord, I make two alternative arguments when it comes to the
Mr.
legislative importance
Mr.
of
Faisal,
appeal.
before
Ji,
going to
ji, ji.
answer the question of
Ji,
my lord,
ji.
please complete that page 18, paragraph number 16 of my lord Hassan Rizvi. This is
Sorry?
very interesting paragraph, paragraph 16, page 18.
Para 16, sir. हाँ सर जी जी ये भी बहुत इंटरेस्टिंग है. आई एम सॉरी, दिस इज ऑल्सो क्रूशल टू दिस. मैं पेज 18 पे हूँ सर, पैरा 16. It's very important that what Justice Hassan Rizvi has reminded us is very important to be reminded all the time. Paragraph 16. Surprisingly, this question, page 18, surprisingly this question has also not been raised in this case, but it has been taken up by my learned brother on his own. The process of judicial scrutiny of legislative acts on the touchstone of the Constitution is technically called judicial review. The courts, however, should adopt judicial self-restraint in discharging their functions of judicial review in order to maintain harmony between the judiciary, the legislature, and the executive. The power of judicial review of legislative acts vested in the High Court, and this court must be exercised with freedom, wisdom and self-restraint, and not in a spirit of cold war between parliament or state legislature and the courts. Non-interference with the view of the majority in parliament with regard to what is reasonable and interference with what is prohibited by the Constitution may perhaps be a harmonious path for a peaceful transition for a glorious future. In Lahore Development Authority versus Mrs. Imran Tiwana, 2015 SCMR 1739, this court, while stating the rules which must be applied to declared laws unconstitutional, has held that if a case can be decided on other or narrow grounds, the court will abstain from deciding the constitutional questions. So, my lord,
Sir Siddiqui, on a lighter note, if I may compliment you, what apparently were apparently divergent views, you have to reconcile all of them.
sir, I try to read everything which your lordships write, whether reported or unreported. Sir, now I'll come back to this, but my reading of your lordship's order is that if, for the purposes of legislative competence, appeal is a part of procedural law, if that is so, then Parliament can also confer appeal.
Not all appeals, but intra-quota.
Intra-quota. 191 read with 58, and the court can also do that.
Court can also.
Yes, the court can also do that. Why is appeal not a restriction? I think an appeal against orders passed under 184(3) are not liberating, are not restrictive. They would be liberating, because it is a problem that there is no appeal against such tremendous power exercise.
This Order 5 Rule 2 that you read, even though we would certainly consider it as an administrative appeal, but practically it is an appeal provided it determines the right of the parties, and the rules are providing for that appeal.
Yes. So this is one way I can add that legislative competence.
I've recorded your contention. Correct me if my understanding is correct. Intra-court appeal liberating, and both Supreme Court and Parliament can provide for them.
Yes.
Okay.
And why
They
did-
are not always restrictive, my lord.
If I may follow what my learned colleague has said with regard to Order 5, why didn't
I can't hear you. I can't hear you. I mean, I can't hear you. So
so sorry. What my learned colleague said regarding Order 5, it's why do the rules use the word reconsider? Why not simply call it an appeal? Because read it, आप उसको पूरा पढ़िए ना, आप उसको kindly पढ़िए. There's a reason why it's called reconsider.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of an aggrieved party by a bench of not less than 3 judges, which may
include the judge who dealt with the matter.
Yes.
It cannot be an appeal. This is not an appeal because it cannot be an appeal.
So
If
this
it
is
were
a
an
review?
appeal, this is not a review.
Reconsideration.
This is a reconsideration.
Sir, it is like a review then.
No, it's not.
Review, practice and procedure में review का power confer कर दिया.
ये देखिए ना,
अगर
deliberately
in an appeal, can't a judge who passed an order sit?
Sir, that is not the notion of how things are.
I suppose he's one judge. I
Sir,
don't
अगर
know. For instance, I'll just give you another example. A bench, their divergent views, right? And the matter is referred to the Chief Justice to send for opinion of the third judge. Alternatively, what could happen alternatively is because one set of arguments were, the third judge hasn't heard the arguments as well, or that particular question as articulated was not put to them.
Yes.
So can the Chief Justice then say, can you all three sit together and decide it? Since now the possibility of a hung court will not arise. It can still go in 3 different ways. So what is that called? I mean, that option is available to the Chief Justice. I'm adding another member on the bench and hear this matter again, or whatever you want to call it.
And if I could add to that, if you look at Section 5, you see, I mean, this is a traditional notion, but if you look at Section 5 of the law, the one under challenge, it says that the appeal would go to a larger bench. Now, I just want to understand whether a larger bench could have this earlier set of judges along with other judges, or a new set of judges as a larger bench. So, I mean, where is this restriction inherent? Traditionally, yes, appeal would be heard by, but could there not be a hybrid system where there could be an appeal to a larger bench in this particular situation, which is the apex court dealing with these matters, and that sort of resolves the problem of 4 and 5 also? Why can't 1 or 2 other judges be added to it? I mean, is there a problem somewhere, or does it?
My lord,
is there
for instance, I'll just further add to it. There have been instances where review matters have come up before larger benches, even during the subsistence of the judges who had earlier passed the order, and they are reported cases. So what is that? Is it a classical review will be heard by the same judges? That's simple enough. Now, this matter has been decided by 2 or 5 or whatever, and one judge has been removed, 3 have been added. So that judge here himself being bench is reviewing the matter, and the others are exercising powers of appeal. Surely they can't be exercising powers of review. I don't know. So these, as His Lordship Mansoor Isha has pointed out, it may be a different category of animal.
Let me just build on what both your Lordships have said. Let us forget about the distinction between appeal and review. Reconsideration.
That is only for the reconsideration, Mr. Faisal. You kindly read Rule 2, which says the reconsideration by the bench of 3 members. If you go through Rule 4, that is an application for reconsideration under Rule 2, and appeal under Rule 3. Appeal is an appeal live from the registrar in all cases to the judge in chambers.
So let us look at this word reconsideration.
Two parts of that. The reconsideration, that would not be considered an appeal, but the appeal is provided separately.
That is against
the order of the registrar in chamber.
That is
and suppose if we were to consider Section 5 and consider it as a reconsideration.
That is why the word reconsideration has been used, in which the judge who passed the order may be included in that bench.
Yes.
So it's not a part of appeal, it is not just like an appeal.
But let us see.
If we were to just say that Section 5 is a reconsideration, and
Sir,
let's not in the word appeal.
Let's just focus on this word reconsideration. What is happening? Sir, मैं एक बात
लेकिन ये आप देखिए, ये जो रिव्यू एक्ट जो पास हुआ था इस एक्ट के बाद उसमें लिखा गया था रिव्यू शैल बी हर्ड लाइक एन
मैं उस पे भी आ रहा था
एंड उसके अंदर स्पीकिंग entirely for myself,
and it was struck down on
that. I have given a concurring judgment in which I have pointed out the serious jurisprudential issues that would arise where half the bench is essentially hearing it as a, because they've heard it before as review, and half the bench is hearing it for the first time, therefore an appeal. You can't mix and match like that.
Sir, let's forget about this distinction between appeal and
review.
Let us concentrate about the word reconsideration. Single judge ने order किया है, उसको reconsider कर रहे हैं 3 judges.
But that is on the administrative side. It's not
Sir,
the judicial
उसमें
order.
applications decide हो रही हैं. अब reconsideration has become, which is in the nature of a review.
All those matters in Order 5, even though, well, it passes for whatever we may call it as administrative, but the substantive rights being decided.
And they have been made a part of a law which is limited to practice and procedure. So the word reconsideration.
Is it on administrative side, Mr. Faisal, or the judicial side?
Ji, sir?
Is this on the administrative side or the judicial side?
This is on the administrative side, sir.
Then why the word use aggrieved party by a bench of not less than 3 members? The bench is constituted.
Yeah, I don't know if this is
judicial side or the administrative side.
Taking that point further, I mean, whether at all these straight jackets about this administrative moving into judicial.
Probably the bard said it best. A rose by name would smell just as sweet.
I would say,
so whatever you call it.
I would say reconsideration and order of your brother judge on judicial applications, if that can be considered as a part of procedure and practice, my lord, then just building on what Justice Munib has said in his opinion, why not appeals as a part of procedural law? So, but that's my alternative. But let me come to my main argument, which is legislative competence as far as appeals are concerned. I rely on entry 55. And like Hassan Azhar Saab's judgment, where he relies on 175.2, the judgment authored by her ladyship Aisha Malik Sahiba has also relied on 175.2, read with entry 55 in the CCP judgment, which conferred an appeal to the Supreme Court.
So, as pointed out yesterday, there is a difference between bringing an appeal to the Supreme Court as opposed to creating an appeal against an order of the Supreme Court. So when you are relying on examples where the appeal is coming to the Supreme Court, it's different. The whole the way of looking at the law and interpreting the law will be different. The question here is not about can this appeal come to the Supreme Court. It's about whether this appeal under 143 amounts to a creation of jurisdiction or whether it is the enlargement of the jurisdiction. I don't see how any of the issues that you are presenting have answered that particular question.
These are two separate
Mr.
questions.
Faisal, I mean, if the appeal comes through a statute, or if the appeal comes through a statute like the Competition Act or the Elections Act or whatever, they are enlarging the jurisdiction of the Supreme Court.
That is
Either way, it goes directly into entry 55.
one of the questions which was raised by Justice Ijaz was that if you create a new appeal, is this enlargement, or this is, because enlargement would imply something being there that is being enlarged. But your ladyship's judgment includes within the term enlargement in para 62 of the CCP judgment 2021 CLD, that enlargement in creation of a new
Can you give me the citation to?
Sir, this is 2021 CLD 214 at para 62-64. But let me come back
Para 62
to 64. But let me come to, there are two parts to the objection which have been raised. The first part is, where does legislative competence come from? Which end do you rely on? The second part is the problem which your ladyship has raised, which is, what is the constitutional procedure to be adopted to confer this appeal, whether it's through an ordinary statute or through a constitutional amendment. Let me deal with both objections separately. Let me first come to the objection of legislative entry and legislative competence. If I may draw your lordship and ladyship's attention to entry 50, kindly, it's quite a complicated entry. मैं अगर इसको जरा ब्रेक डाउन करके पढ़ लूं,
अगर आप पढ़ते हुए ये एंट्री 55 को एक दफा दोबारा से पढ़ें,
वही मैं पढ़ रहा हूं सर,
आप उसमें you miss out on the jurisdiction powers of all courts. What do you mean? What is excluded then? अगर हम आपकी बात माने तो फिर तो आप, क्योंकि उसका जिक्र कॉन्स्टिट्यूशन में हुआ है, तो आप उसकी हर चीज को इनलार्ज कर सकते हैं. वो आप बताएं, आप क्या समझते हैं इसके?
और दूसरा इसमें इसी सवाल में अगर पढ़ते हुए टू सच एक्सटेंट एज एक्सप्रेसली ऑथराइज,
जी,
इसके ये ऊपर के साथ पढ़ना है, नीचे के साथ पढ़ना है, कहाँ पढ़ना है?
Let us read this entry. Jurisdiction and powers of all courts except the Supreme Court. Now let me stop here. Your lordship, ladyship, may just keep your eye on the word jurisdiction and power, because it will occur again, but in a different form. With respect to any of the matters in this list. Now, this of course is not relevant, only to the extent that enlargement of jurisdiction and supplementary powers have to be understood by the first part. So it's a different thing which is being talked about in the second part when one is talking about the Supreme. Now,
और अंडर से पढ़े ना, और अंडर.
जी. And to such extent as expressly authorized by or under the Constitution. So this is the first condition, that if you want to legislate under this entry, then you need a conferment by or under the Constitution.
So is it your argument that this by or under would bring in item 58?
No, this is
okay.
not. But there are two restrictions on this entry. It is not an open-ended entry.
So you're saying that this, to such extent as expressly authorized, is to be read on the first part of the entry relating to the high courts and other courts, or to the Supreme Court?
No, second
or
part.
both?
Second part.
Second part.
Yes.
Okay.
To the Supreme Court part.
Okay.
To such extent as is expressly authorized by or under the Constitution. Now, you need to seek this conferment of power from other provisions of the Constitution, either expressed by or necessary implication. But that power,
55 में Mr. Faisal, ये जो दो लाइनें हैं ना, with respect to the matters in the list, ये तो हो गया बाकी कोर्ट्स के लिए.
ये तो कोर्ट्स के लिए हो गया. ये हमारे लिए
जो शुरू हुआ वो फिर आगे सुप्रीम कोर्ट का तस्करा.
जी. अब सुप्रीम कोर्ट.
हाँ चल, इसके मानी पे एक्सटेंट के.
और इसमें जो express authorization, the words used are expressly authorized by the Constitution. Where do you get the express authorization from?
Yes,
वो explain
but
करके
it is by or under. That is critical.
No. You see, express means express.
No.
It can't be implied. When it says express, then it has to be express.
I'll
You can't read implied
Let me just
into
explain the other two restrictions, and then I'll come back to this.
I am really enjoying your physical motions. It makes me a little dizzy, but I'm really
Sir, I'm
refreshing
sorry,
also.
sir. I'm sorry.
No, it's okay. It's just on the lighter side.
If you stop him, you won't be able to argue.
No. I just find it very refreshing.
Article 2. This is the only exercise I get, sir. Sir, the first restriction is the enlargement of the jurisdiction of the Supreme Court. Now, your Lordship will see the difference between the first part and the second part. You can't legislate in relation to all matters in any way when it comes to the Supreme Court. It must be, there is a restriction involved. You have to justify the law as enlarging the jurisdiction of the Supreme Court.
But expressly or
Yes.
वो बताएं वो कहाँ है?
उसका क्या मानी
मैं
है?
एक मिनट second part पढ़ लूं जी. And the conferring thereon supplementary powers. So it's not that you can legislate on any powers of relating to the Supreme Court. It should be a law that confers powers on the Supreme Court, supplementary.
In addition to what is already mentioned.
Ji?
In addition to what is already there.
Yes. So this is a way to protect the jurisdiction and the powers of the Supreme Court. That if the
पावर दोनों है ना, एक तो enlargement का भी है, then supplemental powers का भी है.
लेकिन सर एसेंस, सर दोनों की एसेंस क्या है? दोनों की एसेंस ये है कि आप कमी नहीं कर सकते, आप इज्जत कर सकते हैं.
हमें जरा उसका मानी बताइए ना, जो to such extent as is expressly authorized by or under the Constitution. We understand the enlargement.
Yes. The way I understand
उसका क्या मानी?
Yes. The way I understand
Mr. Faisal,
it
it is supplemental powers, not the supplementary powers.
सप्लीमेंटल पावर जी सर, दोनों की एसेंस ये है कि सुप्रीम कोर्ट को प्रोटेक्ट किया जा रहा है पार्लियामेंट से कि ये पावर्स घटा नहीं सके, ये जुरिस्डिक्शन घटा नहीं सके. तो करना है तो कॉन्स्टिट्यूशन अमेंड करें. स्टैट्यूट से सिर्फ पावर्स को बढ़ाया जा सकता है.
But you are saying कि 55 is not applicable.
As an alternative argument, 50, I rely on 55.
Faisal, I'm not getting the answer, please.
I'm also not understanding very
सर
clearly.
देखिए, मैंने मेरी पहली
as Justice Ijaz Sahab has said, कि first condition is expressly authorized.
मैं उस पे वो दिखाऊं.
अगर आप कर दे बता दें कि अगर ये बात सही है या गलत है तो हम
मैं बताऊं. Sir, I rely on two provisions of the Constitution for this express authorization under the Constitution and by the Constitution.
How have you drawn the distinction between by and under? Under, yes. How you are saying by means by the Constitution and under means?
You said under means by implication.
By necessary.
From where have you drawn this? Is this your opinion or are you pulling it out of some understanding?
There is a Supreme Court judgment which Indian Supreme Court judgment which I have cited.
No, there is a judgment of this court as well which talks about by or under in terms of Article 240. It has discussed what it is, by or under, what it means. And it says under means, by or under means specifically under the statute, constitutional mandate.
Yes.
Like by some rule of the Constitution or given by some mandate of the Constitution.
Yes.
So it's nothing implied. So your whole argument that this is something that could be implied, it's not implied. By or under the Constitution means something that is expressly provided for in the Constitution.
I'm not saying that it's not expressly provided. When you
implication to koi bhi nahi.
When you read a certain article that conferment of legislative power necessarily follows from, and when I refer to the two provisions, your lordship will see your ladyship will see.
So Article 240 related to the service of Pakistan, it is only subject to the Constitution. इसमें by or under तो नहीं लिखा.
240A में by or under.
240A.
Learned Counsel.
जी.
ये बात वैसे ये क्लियर नहीं हुई.
सर मैं उस आर्टिकल्स पे आऊंगा तो क्लियर हो जाएगा.
आइए ना फिर उस पे, वो एक्सप्रेसली ऑथराइज वाले को तो
डायरेक्टली उस पे आ जाइए ना, जो आपके दो आर्टिकल्स.
There are two articles which I rely on for the first condition.
expressly authorized.
जी. First is, if your lordship has read those articles, let me take your lordship again to 175(2). 175(2).
ठीक. और दूसरा कौन सा है?
दूसरा है read with article 141.
141.
It is only the parliament which can legislate.
آپ 191 اس میں انکلوڈ نہیں کر رہے.
نہیں, وہ اگر آپ اپیل کو پروسیجر میں انکلوڈ کر دیتے ہیں تو 191 ریڈ ود
175 کا 2 ذرا پڑھ لیجیے.
سب آرٹیکل 2.
And this is for all courts.
Yes.
Including the Supreme.
Yes. And this is how it's been interpreted by His Lordship Justice Hassan Azhar Rizvi. That is where the conferment of appellate jurisdiction comes from. 175(2). No court shall have any jurisdiction save as is or may be conferred on it by the Constitution or under any law.
Counsel, this 175(2) is also of the same category where it restricts, it doesn't expand, it doesn't confer legislative competence, it restricts the power of the court to exercise jurisdiction to what is provided by the Constitution or, in relevant cases, what is provided by the law. It doesn't expand, it doesn't confer legislative competence on anybody.
My Lord, I don't read the restriction or expansion in sub-article 2. I don't see that.
It says no.
It simply says
it is couched in negative terms. No court shall have jurisdiction.
Yes.
Which means what? That every court would have only that jurisdiction which is conferred by law or the Constitution.
Yes,
so
but that law can be enlargement of jurisdiction.
Where
Validly enacted under some other provision. That's
Yes.
the point.
the Constitution is giving competence to Parliament, it's couched in positive words, and it is directly telling Parliament that you can make law on this subject. And those examples were cited yesterday. There are numerous examples.
I think before going to Article 175(2), you have to read Article 142.
141.
142, where the Parliament has the power to make laws. Once laws are made by the Parliament, then no court shall have the.
But those laws have to be related to an entry of the legislative.
And 191 comes into field and entry.
With all due respect, your argument is circular. You see, because you start with entry 55, you go to 175(2), and then you bounce back into 175. Entry 55.
It's a ping pong day for you.
Yes.
The law. Oh, we are back to ping pong.
It's a ping pong day for
If I may explain, because
the law over there has to surely mean validly enacted law.
Yes.
And for law to be validly enacted, one cannot look at Article 175(2). One has to look elsewhere in the Constitution. And wherever that may be, a legislative entry, 191, 188, what have you. All of that is the premise of 172. It can't. 175(2) does not of its own. I mean, that's how I understand it. Maybe.
My Lord, let me just read a passage from a judgment which explains my argument, and then I'll further explain.
Faisal, I'll just read this sub-article 2 again. No court shall have any jurisdiction save by or under any law. Now, it's speaking for myself, it's very, very clear that by and under the law, jurisdiction can even be conferred on this court because it relates to all the courts. Now,
इसका सिंपल मतलब ये है कि जब तक आपको jurisdiction नहीं है, जब तक आप सुन नहीं सकते.
The only restriction is in entry 55.
Yes.
It can be enlarged.
Yes.
No jurisdiction conferred under the Constitution can be curtailed or in any way interfered with by or under the law.
Yes. Let me just explain.
Mr. Faisal, you haven't explained the entry. Yes, please, could you just take a little time to just explain to such extent as expressly authorized? So where is it expressly authorized in the Constitution? Where is it under the Constitution expressly authorized that you could enlarge the jurisdiction under 184?
May I explain that by reading a passage and then I'll state my argument. 2021.
So I take it that you agree with us that 175(2) does not confer